How's it going, everybody? In this video, I will be covering all the information you need to know going into the Supreme Court oral arguments on the New York State concealed carry permit case. So let's talk about this. But real quick before we jump into this video, if you think it's time once again for the Supreme Court to uphold our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, in this video, I want to cover all the basic information that you need to know before the Supreme Court holds oral arguments in the New York State Rifle and Pistol Association v. Bruen concealed carry case. Now, if you're not aware, the Supreme Court will be hearing oral arguments in this case challenging New York's concealed carry permit scheme on November 3rd, so next week. One update I have for those of you who have been following this case and been following this issue here on this channel is that the Supreme Court did grant the U.S. Solicitor General the ability to participate in those arguments. Because of this, at the arguments, the petitioners, New York State Rifle and Pistol Association, will have 35 minutes to argue their case before the Supreme Court. Then the state of New York will have 20 minutes, and then the Solicitor General will have 15 minutes. So that is the time allotment for these oral arguments. Now, for those of you who are not aware of what's going on in this case is a challenge to the state of New York's concealed carry permit requirements. The state of New York requires a person provide proper cause to be issued a permit to carry concealed. The issue is that the state does not consider self-defense a proper cause, and therefore on that justification alone, people have their permits denied. Essentially, a person has to distinguish themselves from the average person to be granted a permit to carry. So the whole question is whether the state of New York violated the Second Amendment when they denied various permits using the rationale that self-defense was not a good enough justification for someone to be granted a permit. So that is what the Supreme Court will be addressing in these oral arguments. Now, I want to give you all a quick rundown of the arguments presented by the parties in their briefs, because these arguments will pop up during the oral arguments, and the Supreme Court will be challenging those positions of those various parties in their briefs. So first, the state of New York argued in their briefs that text, history, and tradition indicate they have the ability to restrict concealed carry in public places. Second, they argued that means-end scrutiny is appropriate, and that their law passes intermediate scrutiny. In contrast, New York State Rifle and Pistol Association argued that text, history, and tradition confirmed that the Second Amendment guarantees a right to carry handguns outside of the home for self-defense. And second, they argued that New York's restrictive carry regime violates the Second Amendment and fails under any level of scrutiny, but they advocate in their brief for a higher level of review, not simply intermediate scrutiny. These two topics will likely consume a lot of the oral arguments that we will hear, since they are very important. Text, history, and tradition was argued heavily in all of the briefs, and each side argued that text, history, and tradition supports their position. When text, history, and tradition is going to be brought up during these oral arguments, expect that the arguments will be based on English law, which was in place prior to the formation of the Second Amendment, early US law, and then also current laws restricting the right to carry out in public. So when text, history, and tradition pops up, you'll hear a lot of historical arguments. Also in the briefs, both sides argued what they believe is the appropriate level of review on this constitutional issue. New York State Rifle and Pistol Association wants a higher level of review, which of course I agree with, but the state of New York and the Inspector General, who is part of the Biden administration, argued for a lower level of review being intermediate scrutiny. The tiers of scrutiny are elements and methods of constitutional analysis in which courts examine the goal that the law purports to achieve and the means the law uses to accomplish that end. It's called tiers of scrutiny because the tiers go from easy to pass all the way up to hard to pass. Rational basis is all the way at the bottom of the tier, intermediate scrutiny is at the middle, and then strict scrutiny is at the top because it's the hardest type of scrutiny to pass. Government agencies and states that pass anti-gun laws often argue for intermediate scrutiny, like they did here in this brief and like they will argue before the Supreme Court, because if a court adopts that position, if they adopt that type of analysis, it's easier for an anti-gun law to be found constitutional. Again, this discussion of the type of review that should be applied will likely consume a good portion of the oral arguments. And just keep in mind, New York and the state and the Biden administration through the Solicitor General wants the court to apply intermediate scrutiny, and the petitioners / all of us want something more. We either want strict scrutiny to be applied, or we want the correct type of analysis, which is not strict scrutiny, but instead categorical scrutiny, which the Supreme Court actually established and used in Heller. So the type of analysis that will be used is important because it impacts not just this case, but also other Second Amendment cases that maybe were even decided by another lower court using intermediate scrutiny. Another interesting thing I'm looking forward to seeing is how the state of New York will be pressed on their shifts in arguments during the briefing and during this case. Prior, they had argued that the Second Amendment does not protect the right to carry outside the home for self-defense at all. But now in their briefs, they're arguing that the Second Amendment does protect that right, but not in populated areas, and that it also does not protect the right to carry outside the home in a just general and hypothetical need for self-defense. Instead, you would need some sort of evidence-based need for self-defense, not just merely speculative or hypothetical. This is an important shift in argumentation that the state of New York just tried to brush over in their briefs, but essentially they have shifted their entire argument from saying there is no right whatsoever to carry outside the home for self-defense under the Second Amendment to now conceding that yes, there is that right, but they're trying to say there is that right, but only in limited situations, only in rural areas, non-populated areas, and only for self-defense if you actually have some sort of evidence to have that as your justification, not just merely hypothetical or speculation. And again, that's a big shift in argumentation, and I would hope and I would anticipate at least one of the justices, hopefully Justice Thomas, would press them heavily on this concession that they have actually done in their briefing. Now, a lot of you have been asking me, what should you expect from these oral arguments? Well, first, it will be in audio form, and I will try to provide you guys a link to it that day of. And also, I'm going to be doing a live stream, so I'll give you some more information at the end, but I am planning to do a live stream of those oral arguments with you guys. But one of the things you should expect and will happen is that various justices will take turns interrupting the speakers to ask them questions, and also they will be presenting hypotheticals to the speakers. The goal of the questions and hypotheticals is to actually find the limits of each party's position. So they ask very hard questions, very hard legal questions, and then they ask very hard hypotheticals that are really hard to answer, essentially to find the outer limits of the various arguments that each side is presenting. Also, one thing to note is from the questions and hypotheticals, you likely can gather where maybe that specific justice is leaning, because a lot of the times the justice is very aggressive against one side in asking their questions, and maybe is even very irritated with one of the sides in the responses. So one of the good things about oral arguments is sometimes you can find where the specific justice is leaning on the issue. But really, when it comes to these oral arguments, the ones I'm really going to be keeping an eye on is Kavanaugh, Gorsuch, and Amy Coney Barrett, because they are really the big question marks. Kavanaugh was on the DC Circuit Court in the Heller case, and he has supported the Second Amendment and two-way rights and issues like this in the past. Amy Coney Barrett clerked for Justice Scalia. She claims to be a textualist and originalist like Scalia, who wrote the Heller opinion, and she even wrote a dissent in the Circuit Court case Cantor. So it seems like at least they're leaning towards the Second Amendment, Gorsuch as well, but you never know, and it's going to be very enlightening to see the questions they're asking and maybe their demeanor during those oral arguments. One important thing I want to note is that the court will not be issuing a decision on that day, so don't expect on November 3rd for them to issue their decision. That's not going to happen. Now, like I said, if you want to listen to the oral arguments live with me, let me know down in the comment section, and also I'm kind of planning on doing that. I think there's enough interest in there. So also make sure you're following me over on my second YouTube channel, where I will likely be hosting that live stream, and also where I put my podcast episodes. So if you're interested in listening to that live stream along with me, I'll put a link to that second channel down in the details section, and make sure you're subscribed to that and you're following that channel. So if you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos, in this type of two-way news, and then it helps push it to more people. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are definitely impacting these videos. You're impacting the channel. You're helping this to reach more people, to help spread this two-way news, and I cannot thank you enough. My goal was to try to reach 200,000 subscribers by the end of the year, and that was a very lofty goal. It wasn't looking like it would be even possible, but because of you guys, it's looking like I will meet that goal. So if you guys aren't subscribed, I would greatly appreciate it if you are subscribed, or you would subscribe. And also, if you just don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm, and that does help the channel. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will maintain by armed scholars.